Well, hello, Lyric Armstrong, your real estate agent and advocate. We are here, Landlord Tenant Law. We are still in a court with Judge Simpson, enjoying his docket, and Attorney Mack is back. So we get to see Attorney Mack maybe in his better light than he was the last time or the first time we met him. All right, so come on in, make sure you like, share, and subscribe. Now let's get on into court. Thank you guys for giving me your commentary on the last video. I appreciate that. Always appreciate getting some feedback. So thank you so much. Now we're going to get back into court. All right, Judge Simpson, we're ready for court. And here's Attorney Hugo Mack. This is his name. Let's see.
Ping Shin versus Kayo Akupong and Akupong. I mispronounce those names, but I do every time.
Quick reminder, we like to keep the sound up so that we can hear some of the nuances, especially if someone's away from the mic. So consequently, unplug if you're plugged in or turn down your volume just so that you don't harm your ears.
Good morning, Your Honor. Hugo Mack appearing on behalf of plaintiff.
Good morning. Good morning. What's your name, sir?
Mr. Ashenpong.
All right. This is a motion regarding installment payments. Did you?
And I just want to say kudos to Judge Simpson's clerical team for getting his name changed very quickly in his renaming. So good job for that.
File,
I appreciate it.
Statement of income and expenses, sir.
Always got to
Yes, we turned it into the we turned it into the court. We put it in the Dropbox.
Okay, that was on the 28th. Mr. Hang on a second. Mr. Mack, have you received a copy of it?
No, Your Honor. I believe the court has gotten in its possession our objection that was filed with the court some days back, where I clearly state that on the 18th, you were very specific that the defendants were to provide me with all documentation. Mr. Akamengapong did not file a statement of income. What he did is file 50 pages of sundry disjointed records.
Okay. Mr. Mack,
but
without all superlatives, have you received a copy of what they filed?
Bottom line, Mr. Mack is ready to argue his case. He has characterizations as to what type of evidence he has received. And basically, he's saying it's not responsive to what the court has required of them, which is the income. And judge is like, look, yes or no, you have it or you don't.
I did not receive them, but I did review them, and I'm prepared to proceed, Judge.
All right. That's what I need to know. All right.
So you may say, what? How did you receive and not receive and review? Bottom line is when you file something with the court, you also have to serve the other side, which in a lot of instances can mean just as simply as putting it in the mail. Depends on what type of service is required for that particular document or what you have agreed upon as parties. Usually email is not considered a formal form of service, but it can be if you do agree upon it. So Mr. Mack is saying they have not served me with the documents, but they did, in fact, upload them to the Dropbox. So he probably has access to that and has read them or reviewed them from there, is what I surmise based upon the information presented.
All right.
Okay.
Mr. Inkapong, how much are you proposing for a payment plan on this?
Sir, we were trying to pay 300, 350 at the most, just due to the income that we have.
$350 a month.
Yes, sir.
All right. And Mr. Mack, what are you saying in terms of a payment plan? Or are you objecting to a payment plan in its entirety?
No, Your Honor. What we're saying is that Bush's, Mr. Akamengapong's primary employer, has calculated his duly and legitimate expenses that are mandatory, like state and federal income tax, and they have garnished $260 a week in accordance with his income. We would like that to continue. And Mrs. Agamengapong, we've received absolutely no information from the Ypsilanti Community Schools on her because she is a seasonal employee. So to cut to the chase, Your Honor, I know this court is very fair-minded, and even if people, whatever, I fully
I
respect
don't need
that.
all that. I just need a number that you're looking at.
I'm looking at $260 per week from Mr. Agamengapong's account, and I'm looking for at least $150 a week from Mrs. Agamengapong's account, which we don't even have a record from the Ypsilanti Community Schools yet because she's not
I
working.
heard you the first time.
Sir, there's no way that I'm going to be able to continue that. That's the purpose of this hearing here, is because I'm going into debt, clearly trying to pay all of these bills, and you're taking $260 out of my check every week. I mean, it's not adding up. All of my bills are behind. I'm trying to catch up. I'm not going to be able to catch up and continue to pay $260. I'm falling. I got 4 kids at home. I'm married. I'm trying to take care of everything. My wife doesn't work. She's a seasonal worker. So she hasn't even really gone back to work yet in order to get a check.
Your Honor, I would remind the court that Mr. Agamengapong and Ms. Agamengapong failed to inform the court of their jobs at TJ Maxx, Your Honor, in all their pleadings, Judge. They also failed to reveal the bank accounts, which we've given you bank accounts in a confidential exhibit admission that they've failed to inform the court about. The man and wife, the husband and wife in their pleadings, Your Honor, told you they were each paying $1,700 a month for rent. Okay, giving the false impression that each of them were paying, excuse me, if I could finish, sir, giving the false impression to the court in their pleadings that they each were paying $1,700 a month. That's not true. They're paying $1,700 jointly. They both said they are individually paying $31,000 on a Chrysler Pacifica. That's not true. They're paying that jointly. So what I'm saying, quite simply, Your Honor, is that the
I heard all of this the last time, Mr. Mack. I mean, I'm not clear why you want to keep repeating it to me.
Your Honor, I was just simply replying to the statements of the defendant.
The court has reviewed everything, and based upon what the court has before it, and clearly, if the amount were the 25% of income as the standard for it, there would be no need for petitions for installment payments, because the court is trying to balance what they can afford to pay each month as opposed to having the 25% taken out. So from the court's perspective, what the court is going to do is the defendant is to pay $500 per month. That is going to be the court's order. The garnishment will be suspended at this time. I'll set a review of the payment plan for January 5th. January 5th. I will set that at 8 a.m. Once we have our time block set, you'll get the specific time blocks for that January date. Thank you.
Wait, sir, when is this supposed to start?
This will start September 15th.
Your Honor, I need some clarification from the court, please. I apologize. Mr. Agamengapong's wages will be garnished $500 per month starting the 15th of September. Is that it?
You only have no. Well, the payment plan will be that the garnishment becomes suspended as long as those as long as that $500 per month on the 15th is made.
And where do we make those payments to?
Do we make those payments to the court?
No, you make those payments to Mr. Mack's office, I'm sure, or to Plain. Once the order is done, the order will specify where it's to be paid. Mr. Mack will be responsible for preparing the order. Thank you.
Thank you.
Okay. So, Attorney Mack did pretty good this time, right? You can get into it with the judge. If you remember the first time, you go back and see that case to see it live. It's in one of our videos where I believe it was something in the title about where the attorney fails or falters or something. He gets very snippy with the judge the last time and ends up costing himself a great deal with his client, and with his care for the last case. But this particular case, Attorney Mack did pretty good. He didn't get too snippy, and kind of like, so they were, okay, so I did the math. So they were collecting $260 per week from garnishment of wages, which comes out to $1,040 per month. And then they were petitioning tenants were petitioning that they only have to pay $350 at the most per month. Well, Attorney Mack, of course, also said we're only getting paid from one side and not the other. One party and not the other party, meaning that whatever I guess she's working seasonally at the school, and consequently, he's saying, but Your Honor, also want you to take into factors that they are not reporting to you the actual truth relative to their income and their job security as to what their jobs are. And, somewhere down the line, someone's working for TJ Maxx and they're not expressing that, and so forth and so on. So he wants to collect $150 a week from the young lady, the wife, and $260 a week from the husband, which this would total to $1,640, and they only want to pay $350. So basically, that's $1,290. So this is how far apart they are in relation to what the Attorney Mack says they should be able to pay and be able to work over versus what they actually want. They're not even in the same time zone, right? They're way across the way. But garnishment is kind of set up more like punishment, kind of like, court doesn't want to garnish, especially if you're going to make the payment. So that's why the judge is like, no, it's suspended for now. If they go ahead and make payments in accordance to my ruling, then fine, no problem. Attorney Mack, they didn't get what they wanted, $350. They have to make $500 a month payments. That still is $1,140 different than what Attorney Mack was trying to advocate for his client. It's obviously payment in the rears of what they owe. So it's, they want to collect their money, right? But the court doesn't want them to go into bankruptcy trying to pay one debtor and not being able to pay the rest of their debtors. And it starts now. They have, evidentiary or, the hearing coming up in January to go over and see if it's.
Court calls a case, showcase investment.
Forgot how loud it is. Okay. All right, let's try the second case now. And we're still loud, so don't be alarmed.
Versus Jorge Berlenga.
Good morning, Your Honor. Krista Davis appearing on behalf of Showcase Investments, LLC.
Good morning, Your Honor. Melvin Babby appearing on behalf of the defendant, Mr. Berlanga.
Yay, yes, an attorney. I love it when they have attorneys.
Okay, and where are we on this case? I'm sorry.
Your Honor, last time we were here, we asked for, the defendant asked for an adjournment so that we could discuss. We did have a chance to talk. We don't have a settlement in this matter. My client would like to move forward with a forfeiture hearing.
Any response from the defense?
Thank you, Your Honor. We think there are numerous issues with the accounting and the balances owed, and we believe it would be fruitful and we would be entitled to an accurate accounting of the balance. The plaintiff has accepted payments post complaint filing. There's evidence that there's been payments made by the defendant that haven't been applied, and also there's clear errors with the escrow as provided by documentation shown by plaintiff. So there's definitely a basis to determine what a true balance is. And
have you guys discussed the payments and other things or an accounting?
Well, Your Honor, my client has a ledger that it's been available 24/7 to the defendant the entire time that this home has been rented. So I've not seen any evidence from the defendant regarding payments being incorrectly applied, but I do have the ledger for my client showing how she applied everything.
Okay, so kudos to her client, the landlord, for having the ledger online so that the plaintiff, the defendant or tenant can have visibility of it whenever they so choose. So as a tenant, heads up, if you are having that type of access, please check it. Check it, make sure that things are being properly inserted. I don't know how long the tenancy has been, but if you had a long-term tenancy and now all of a sudden you realize that $20 per month is not being allocated correctly or some of the payments you've made have not been posting to the ledger. You need to make a reasonable time frame of objection or call out. And there might be something in the lease, which is a contractual agreement, that may have a clause in there that says if there is any discrepancies in payment, you have a certain time frame to let the landlord know. However, I don't know that it would stand up so much in court, but at least it would show that you have an agreement to abide by such terms. And if you don't abide by such terms, maybe they can get certain arrears cut in half or, disregarded because of time framing. Not typical for the legal side of things, other than the fact that it would be in the contract and both sides agree. So it's something that's up for interpretation relative to the law before the court to make a final legal finding. But a proper ledger is important, and you're not allowed to take payments from the tenant after you have served them with a unlawful detainer. You can't take payments any further than that. Payments by the tenant should go into an escrow account to be held. Once the court has agreed upon what the final amounts are owed, then payment will come out of that escrow. Then you shouldn't be taking your payment down to the landlord anymore, and the landlord shouldn't be receiving them. Why? Because this issue comes up. One of the things is there's a stop. Once the landlord says you haven't paid me and consequently we don't have funds in escrow or you haven't made these payments, whatever have you, so we want you to vacate the premises, then you put your money in escrow versus giving them directly to the landlord, because now the court has to take into consideration what the evidence is, what part of the evidence is pertinent, what isn't, what does it show, what's the final finding, and then they issue an order or judgment. So the court will tell you how much you owe in the end. And sometimes you have the factors that you have all of your rental amounts plus court costs. It's not just the rents. So, these things, the numbers start to not add up if you're continuously making payments. And in this instance, they're saying they're not even being allocated and put into the ledger. That's another problem, right? You should always have it put into the ledger. You always, have correct accounting. And this is a big deal. So we'll see what happens. But we'll most likely have to see this another day because I doubt that this is the hearing for it.
And we're saying there's definitely errors and inconsistencies.
Okay, well, counsel, I understand what you're saying, but you've got to provide that information to plaintiff's counsel so that she can compare it against her ledger and with her client.
That has been, Your Honor. For instance, just as an example, the plaintiff provided a mortgage balance statement that the plaintiff has a loan on the property.
Okay, have you given that to plaintiff's counsel?
Your Honor, plaintiff's counsel provided that to me, just as an example. There's an escrow amount that's withheld every month for the taxes and insurance. That amount is less than the amount that's being charged.
So you guys just aren't talking and discussing the issues.
That's an interesting statement that judge is speaking over him, so I'm not really hearing his point on that. But the tenant is not responsible for the mortgage because the tenant is not the homeowner. The tenant is responsible for the lease amount, what the rent is agreed upon based upon the contract of the lease. So, then the landlord takes the money, pays the mortgage, puts things in the escrow account or whatever. So I'm a little confused as to why he's making the statement in representation of the tenant, unless they're doing some kind of lease back. If they're doing a purchase rental, maybe that would be an issue to the tenant, but otherwise, what the landlord does with the money doesn't matter unless it becomes an issue for the property. It becomes an issue for the property if the landlord is not making the payments and they go into foreclosure and now the tenant can't be in the property anymore. That would be something of an interest for the tenant because they have an interest in the property and the landlord's not, paying the mortgage. But if there's a percentage of the mortgage that's going into escrow for the taxes and, it's usually taxes and insurance, I believe, that's in the escrow account with the mortgage company. That's not relative to the tenant.
So we'll all have to do this together. I'll set a final settlement conference. Or late today.
Okay, so we're coming back
Tuesday the
again.
19th at 9 a.m.
So I'll set a final settlement conference for September 19th, 2023. What time?
9 a.m.
9 a.m. That will be in person. And you guys bring all your documents. If I got to add it up and do everything, then I'll do it for you.
Thank you, Your Honor.
Thank you.
Have a great day.
Thank you.
Triple R Invest Development LLC versus JP Torching and Demolition.
Poor judge. I mean, most attorneys are like, no, thank you for doing math. It's like, no, thank you for math. We're critical thinkers. We do not want to add and subtract and divide and multiply, but we can do it.
It's gonna take me a little bit. It's gonna take me a little bit. I want to talk to you. So. Go ahead, counsel. State your appearances.
Good morning, Your Honor. Rebecca Haynes appearing on behalf of Triple R Development.
Good morning, Your Honor. Attorney Patrick Barry, PH 4539, working demolition.
Okay. So you guys are all settled, right?
Okay, I'm going
Yes, Your Honor.
You are?
Yes, we submitted our conditional dismissal. We have a settlement agreement. And then there's some secured transaction agreement as well for some equipment that we are holding as collateral.
All right. So judge is like, yes, parties can agree outside of court. Here's evidence of it. Yay. It's always a good thing because court does not want to have to intervene, but they are there to do so when you just cannot agree.
That's correct. Your Honor.
All right. I see that. I did not see the COD. I see it there. Thank you. God bless you. I've signed the COD. This matter is conditionally dismissed. Thank you, guys.
Thank you, Your Honor.
So, conditionally dismissed, dismissed based on conditions and certain conditions for which they, kind of ran through, but it's in the order in and of itself. It's phenomenal. And hopefully, I don't know if it's automatic, but I definitely would want and suggest to have a dismissal of the matter versus having a judgment on them. So I guess with conditional dismissal, meaning if all conditions are met, then we will dismiss the filing. And therefore, it looks as if the case was dismissed. You don't have to tell a person why it was dismissed. Dismissed is dismissed. They don't really need to know. And therefore, when you go into another location and you are trying to get a different rental and, they're looking at your credit and your history, it's not something that's dinging upon you as a tenant. And so that's more preferable, in my opinion, versus judgment, because a judgment means if the court had to intervene and they saw cause, they saw problematics with, between your tenancy, and they've put an order against you. And that's something that's disparaging, or at least does not bode well when you go off to get a new rental agreement.
Great weekend.
You guys do the same.
Yeah, great.
Group
weekends.
5 Management versus Kari Jones.
Morning, Your Honor. Robert Weiss appearing on behalf of Group 5.
Okay.
Good morning, Your Honor. This is Kahari Jones.
All right. And where are we on this case?
Okay, we received communication the last time we were here that Mr. Jones was going to have help in paying the rent. Would have been the full amount. We haven't received the check yet. It's supposed to
Being him up there.
And that's through Hawk. Amy, any news on this one?
Your Honor, do you have a confirmation letter, Mr. Weiss?
I do.
Okay. Then payments are still being sent out. I think that this one payments were supposed to be sent out today. For some reason, that date is sticking in my mind.
Okay.
Believe that's
Here's what I'll do.
Probably
All
correct.
right. If we have the confirmation letter, then I'll just adjourn this to September 15, 2023 at 1 p.m. And hopefully we'll have the check and all the payments in at that time.
But they won't be paying September's rent, so September's rent will be due.
Well, then then we'll have to deal with September's rent. But let's see what payment's coming through.
Okay, so I've vacated the property. Just want to let you know that. And I've been trying to return the keys, but the office just hasn't been open, even though they said they were. But I have vacated the property.
Mr. Weiss, any news on where he might be able to return the keys?
It should be returned to the office has been closed. Is there a Dropbox there, Mr. Jones?
Yeah, there's a Dropbox, but I wasn't sure if I had to hand it to them directly or not. But I can leave it in the Dropbox.
And make sure that your apartment number's on it. When did you vacate?
I vacated on the 31st, like I said, so yesterday.
Okay, and did you give them proper notice?
Yes, I submitted it in writing at the office prior to vacating. I forgot what date I submitted it, but I submitted it.
You don't know what date you submitted it because it's got to be 30 days.
I don't remember when I submitted it.
Okay, well, you guys can work that out. You get the keys in there. Come back on the 15th. We'll sort that out. Thank
Okay,
you.
what time was that, Your Honor?
1 p.m.
1 p.m. Thank you. Have a nice
Thank
holiday
you.
weekend.
I wasn't even really paying attention to the time frame. I just enjoyed the fact that his court reporter was on his calendar clerk.
You do the same. Sycamore.
Right. When it comes down to vacating a property, we'll listen to maybe one more court case, but when it comes down to vacating a property, you have to return the keys. But you don't necessarily have to give it to them in hand. Okay. I do understand his fear. It's like, well, you know, I don't want you saying I didn't leave the keys or whatever. But, you know, you put it in the Dropbox, make sure it's in the envelope, says, you know, what apartment number you are, and then send them an email or whatever form of communication in writing that you're used to doing and saying, I vacated, I dropped the keys off in the Dropbox, because no one was, you know, there. Such a time, whatever. And that's great. And you'll have a record of it and you can prove to the court you did it. I mean, they're going to change the locks anyway. I think maybe the main keys are probably the ones that they're not going to necessarily rekey, which would be like the gate key or something like that, or the pool key, or the rec room key. Those keys, that particular main key, is most likely they're not going to touch that. When it comes into your apartment, they're most likely going to change that lock. So drop the keys off so that you don't have possession of it quick, fast, in a hurry, and then that way you're not responsible. Okay, let's see. One more.
Sycamore Meadows versus Shikila Road, or Hodges, excuse me.
Good morning, Your Honor. Alice Friedman for the plaintiff.
Your Honor, I believe Ms. Hodges is on the Zoom, but I am advising her on this case, and I wondered if at the beginning would be a good time for Mr. Friedman and I to talk about negotiations and conversations our offices have had this week.
Your Honor, we've got 9 cases left. I think that we're going to dismiss one today. I think we're down to 8. Would it be possible for us to have a very brief session with Your Honor to do some off-the-record scheduling and discussion?
I didn't set up my other iPad.
And could Ms. Bauer join as well if we're able to.
All right. Okay, very good. We'll go into a breakout.
It'll make things a lot quicker, I think.
All right.
All right, so. Tracy.
Okay. So everyone's going into a breakout room for whatever he said the reason was. Okay. We're back. We're waiting on the judge to get back. Try not to cover up anyone. We got new people.
I think now I'm back. Right?
Yep.
Okay. Hold on. Okay. So record should reflect, and let me call all of the cases. Sycamore Meadows versus Hodges, which I called Sycamore Meadows versus Gibbs, versus Haynes versus Hobbs, versus Brown versus Stafford, and versus Gross. In those matters, council has agreed, and unless there's an objection, I'm adjourning all of these to October 6th, 2023 at 1 p.m. I am also ordering escrow in all of those matters from today's date forward. That would mean for the tenants would have to pay their September rent, if they owe September rent, into court escrow. That needs to be paid in cash to the court. Council is going to work out the details and the amounts in the orders and submit those orders to the court. That's the court's full understanding of how we're going to address all of those cases today.
That's my understanding.
All right. Do any of now, Ms. Jensen, you indicated that there are some tenants that you don't represent but are advising.
Yes, I advise Ms. Hodges and I was advising Ms. Billups. Do you want to know how the cases are wrapped up? I mean, the appearance we have filed is for Allison Gibbs, and that's Ms. Bauer.
Okay, I'm not so much concerned about that. I want to make sure that any tenants that you're not representing understand what the court is doing with their cases today.
Your Honor, there is one name that you called that has not made contact with our office about assistance or representation. And that is Ms. Brown, and she's saying that she's having trouble with transportation.
So I just wanted to make sure that, if you were including her, that she knows that she needs to make contact with our office about her case.
All right, Ms. Brown, do you understand that?
Hi, Your Honor. Yes, I do. Unfortunately,
Okay,
I was
so you need to contact legal services and they'll be able to explain to you everything, but your next date is October 6th.
Thank you. Oh, and I asked
All
a
right.
question about being able to pay online because you said to pay in cash to the courts.
Yes, it has to be paid in cash to the court.
Okay. Thank you.
Okay, so we'll work with the legal services and we'll be able to figure that out, okay?
All right, thank you.
Ms. Brown, this is Callie from Legal Services. I apologize for interrupting, Your Honor. I just want to make sure Ms. Brown has our contact information, and if not, we can put it in the chat.
Yes, if you could put it in the chat, that'd be great.
All right, everybody, thank you.
Thank you, Your Honor.
All right, so that was another, the thing about Judge Simpson's court is I don't care if it's his criminal docket or whatever. He moves things so quickly. He has a great number of matters that land on his docket, so he moves so quickly. But this is like perfunctory ancillary task right here. They're just moving it on to the next state for whatever reason. That was, really expressed through the breakout. Interesting that there's 8 different tenants for this one particular landlord. Doesn't necessarily mean that they're in the same location. The landlord could have different properties. But I just wonder if the landlord is trying to evict everyone so that they can do something else with the property, like tear it down, rebuild, or sell, or something else.
Court does call the case of Sycamore Meadows versus Livingston.
Ellis Freeman for the plaintiff.
Jay McCurgy appearing on behalf of the defendant.
All right, and
anyone else?
We on this one, folks.
Escrow was ordered, Your Honor, and I don't think it's been paid.
It's the first of the month, Your Honor. We have that check right here.
You have a check. You're holding a check.
You gotta.
This is for rent for September.
You broke up there, counsel.
Oh, Your Honor, this is rent for September, and she paid $350 last night from her check.
Okay, so she's going to pay that to the landlord.
Correct.
Okay.
So that would take her up to 1,025, I believe. You had asked her to pay 1,000 by this court hearing, so we are here.
Okay. So if that goes through, Mr. Friedman, how much did she?
Well, that'll get her under the 3,000.
Got it. And has she applied through Hawk? Is that the deal?
Correct. And we have a date set for September 5th.
You're breaking up on me, counsel.
We have a date September 5th for Hawk, meeting with Hawk.
Okay. So did you want me to then set this out to September 8th or September 15th, which would make more sense?
15th, probably, Your Honor.
15th? All right. September 15th, 2023 at 1 p.m. Okay? Very good.
Thank you, Your Honor.
Thank you, folks.
Thank you, Your Honor.
All right. Thank you, Your Honor. So we'll go ahead and let that be that for today. We learned a great deal about some of the, ancillary tasks. If you have a garnishment, you can do an appeal. You can go to court petition to see if you can negotiate a different amount. They did not get the $350 that they wanted. They got $500 a month, but that's far cry from what the plaintiff wanted, which was $1,600 a month. So they're still up on that. And then, so the last couple matters are just relative to setting different hearing dates and moving forward in the future. This particular last one, of course, you saw that there was a check that are supposed to be making cash payments, but they did have an attorney that could say, I do have a check in hand. Today's the first, Now, if you are in Michigan and you are making that list we talked about before about understanding what types of services could be helpful to you, and what if you are in the rears of rent and needing to have that service, looks like there's another one that just was expressed. It's HAWK, HAWK. So write that down. That might be of service to you. They have been helping some people post panorama, so that's a good thing. A lot of times you'll hear some complaints that they cannot, in fact, receive any help because after the panorama, all the funding kind of dried up. So this particular one is still moving forward. So if you need that assistance, please use it. Be proactive. See what the process is and see if it's going to work for you. All right, so I'm Lyric Armstrong, your real estate agent and advocate. Don't forget to like, share, and subscribe because as you may know all things, someone on your sphere does not. So share with them so that they can be informed. Remember, we're talking about very sensitive matters, financial matters, rent and income matters. They're very sensitive. So a lot of the people in your influence, your sphere of influence, your friends, your comrades, your social specter could even be just associates by a generational, skip, friend of a friend. You're probably not talking about this, right? You're having tea and coffee and sitting down and having lunch together, but you just most likely are not talking about financial concerns. So you really don't know who needs to know. This is why we just go ahead and put it up on the site. And those who need it can watch it at their leisure. And you don't have to find out and see which one of your friends is in dire needs, because if you know, then most likely they're asking you for the money. So let's avoid that. That they don't have to ask you for the money. They can go and ask Pop, right? And see if they can be helpful or some other services that are in there. So make sure you share this information. Lyric Armstrong, real estate agent and advocate. So glad to have you. Thank you and see you soon.